judicial review. And he does all kinds of asylum appeal work and deportation appeal work as well. And so Hannah and Raza are both experienced colleagues of mine, and I'm Mark Symes, so I'm the convener of the immigration team at Garden Court. I'm as well as being a barrister, I'm a deputy upper tribunal judge, and in fact this year I've been put on the national first tier tribunal training team, so actually now I actually get to train the judges that you might get to appear in front of. So who knows, hopefully I'll have something insightful to say, as will Hannah and Raza. Right, I'm going to attempt screen share now. Here we go. So, just to start off with, introductory point on new legislation. This may or may not be self-evident to you, that when legislation is passed, it doesn't come into force immediately. It comes into force usually in bits and pieces. And to work out what's in force at any particular time, if you're lucky enough, of course, you may have Westlaw or some other subscription service, which, if you manage to navigate it, may tell you, should tell you what's in force and when it entered force. But you can really do it just from the things available on the native internet, because the Nationality and Borders Act, Section 87, there's always a commencement provision in legislation, and it tells you what provisions enter force at when the act is passed. So a few provisions entered force on 28th of April, and then a few more entered force. Most of the refugee regime entered force on the 28th of June. And after that, there were commencement orders passed, and they can be found. They can be just found via Google. So the trick is to find the most recent commencement order. Commencement, so I believe last time I looked, it was commencement number 2 was the most recent one, and the most recent commencement order will list all the provisions brought into force by earlier commencement orders. So there's no great mystery really to working out what's in force then. Sometimes the commencement orders contain transitional provisions which are pretty heavy going sometimes, though probably not on this particular piece of legislation, happily for us. So that's the methodology about working out what enters force at any particular time. And not only do we have a new legislative regime for asylum, we also have the new immigration rules that in general entered force on 28th of June 2022. I think some bits, it gets quite complicated, doesn't it? I think some things entered force on the 20th of June. I think the new private life route might have entered in force on the new 20th of June, but anyway, the new private life is not the focus of our considerations today. So what we're told, I think it's made pretty clear in the legislation, but the rules also tell us that this regime commences for people whose asylum claims are made after 28th of June. So if you made your claim prior to 28th of June, you're in the old system, which is pretty smart. Because as you will see, there are various problems with the new system that are going to make things much more difficult for asylum seekers and, sadly, refugees. So here's a brief overview of some of the provisions that we'll be looking at. Differential treatment is a major theme of the new legislation. We have a statutory discrimination system now. Statute authorises a certain form of differentiation, as the legislator calls it, though we might say discrimination, between different kinds of asylum seekers, depending on essentially their immigration histories. Also, there's new provisions for accommodation, but I suspect that's not something that's going to greatly vex your clients. There's new procedures for making asylum claims, which has been on the cards for many years, and in fact, asylum now has its own validity regime. So, as we'll duly see, just in the same way that you may get problems with applications that are invalid in regular immigration law, now asylum could also feature invalid applications, just to put one more obstacle in our path. Inadmissibility, so the third country regime and the regime for EU nationals claiming asylum has now departed from the immigration rules and is moving onto a legislative framework, and that's what Raza is going to be looking at. immunity from penalty regime, and that basically goes hand in hand with the differential treatment regime I mentioned. Substantive refugee law gets some changes, including some, what for most of the time may seem like technical changes in terms of where refugee law now lives, has departed the 2006 protection regulations and moved to inhabit the 2022 Act. But also there are massive substantive changes in terms of criminality and its consequences, and for assessing the truthfulness of asylum claims. And also there's some procedures, and Hannah's going to talk about some of these procedures, in that there's various procedures that are going to enter force, so we don't really know their details yet, still being worked out, or perhaps even negotiated between the Procedure Rules Committee and the Home Office. And it would be possible, much more possible than for some time, to go into various expedited procedures that could lead to a right of appeal direct to the upper tribunal, for example. Okay, so the first big feature of the regime, as I've already mentioned, is the general transposition of law from what was EU retained law into domestic UK law. And that's for people working in a high level of refugee litigation, that may be extremely important. It may well not be important for our routine asylum caseload, but relevant features of this mean that we've had three stages, essentially, three stages in the recent history of refugee law. Up until December 2020, refugee law was EU law, and therefore the Court of Justice was sovereign over domestic courts. Provisions of EU law were sovereign over domestic legislation. Then we've had the regime from December 2020 until April or June 22, depending on what issue you're dealing with, when that legal regime became EU retained law. So definitely the regulations are EU retained law. I believe the immigration rules were EU retained law because they reflected EU directives like the Procedures Directive and the Qualification Directive. So they still had a special status in English law, which essentially trumped competing legal provisions, and still fell to be interpreted primarily by reference to EU law principles and having heavy regard for decisions of the Court of Justice of the European Union. Now, this is very much taking back control, though, and the move of the refugee definition into domestic legislation is intended to quit the era where the Court of Justice was sovereign. And we'll have to decide, English judges are going to have a think about what role to give Court of Justice decisions in the future. I think the starting point is that we would treat judicial decisions on the Court of Justice on what is, after all, exactly the same legal framework. Its habitat may have changed, but the wording has largely not changed. I suspect English judges would take it pretty seriously, but there'll be scope for debate on this area. Standard of proof is changing, which we'll come on to in a moment. One thing is that the House of Commons were pressed in the course of the passage of the legislation to stick the Refugee Convention on the statute book, and they considered, though, that not only stick it on the statute book, but to confirm compliance with the Refugee Convention. And they refused to do so. They refused to do so, saying it wasn't necessary to affirmatively state compliance because they believed it was compliant. Well, I wonder, yeah. But obviously, you see what they're really doing is that they didn't want a provision that effectively made the Refugee Convention sovereign over this legislation. They held out for that. So, of course, when they argue these cases in court, no doubt the Home Office lawyers will say, "Oh, no, Parliament has got the last word. It's not the meaning of the Refugee Convention, it's Parliament's words which we're interested in." And that is something that will have to be looked at, no doubt, over time. Okay, transitional arrangements, such as they are. So the relevant transitional arrangements seem to really actually be in the Home Office guidance more than anywhere else, I suspect, because the legislative and rule-based regime just says it's the timing of the claim which is imperative. But the guidance gives us something else. Not clear. I mean, ILPA have remarked that the guidance seems to be inconsistent with the legislation, but I think my answer to that would be, so what? If the Home Office want to do it, they can do it, can't they? Because it's there. They have kind of the last word. As long as it's in our favour, which this is, no problem. So anyone seeking to claim asylum before commencement is treated as a pre-28th of June claim, even if their appointment is after the 28th of June, so long as they attend the scheduled appointment or any rescheduling of it. But if they miss the appointment, unless they can show evidence of circumstances beyond their control, then they will enter the new regime. So basically, pretty important that people go to any scheduled appointment at the moment, on the basis that if they've got an arguable case to get into the old pre-28th of June regime. Okay, so first big issue that I'm going to deal with is lawfulness and so forth. So the problems of refugees have been recognised for many years, and there's obviously it's very difficult for a refugee to access a safe haven such as the United Kingdom, because of many self-evident issues such as documentation and so forth. And this was looked at, this was an issue that was looked at and greatly discussed in the 1950s, when at the Conference of Plenipotentiaries, they drafted the terms of the Refugee Convention. And many of the spokespeople for different countries talked about this issue, and they thrashed out this notion that obviously you should not be penalising refugees for breaches of immigration control beyond their control. And there's the UN Secretary General himself made that point. So this provision was created, Article 31(1) of the Refugee Convention. No penalties on account of illegal entry or presence on refugees who coming directly from a territory where their life or freedom is threatened in the sense of Article 1, enter or are present in territory without authorisation, providing they present themselves without delay to the authorities and show good cause for their illegal entry or presence. So different concepts there, yeah. And essentially, this is going to bite on two fact patterns. One is third country behaviour, and the other is late asylum claim behaviour. So breaking it down, the issues are no penalty imposed for reasons of your illegal entry or presence, so long as you've come directly from the territory of feared persecution. And the protection rides in favour of people who enter or are present without authority, who present themselves without delay, and show good cause for their illegal entry or presence. So that's the sort of key concept. Ademi, big case on this back in 1999, and Lord Justice Simon Brown says that some element of choice is indeed open to refugees as to where they may properly claim asylum. Any merely short-term stopover en route to an intended sanctuary doesn't lose the protection of the article. And when judging whether or not protection is lost, you should be looking at length of stay, the reasons for delaying there. Substantial delays in a third country might not be conclusive against you if you were actually trying genuinely to get out of that country, and whether or not you sought or found protection in fact or in law. And so in terms of without delay, the meaning is claiming asylum in a short time of your arrival. Good cause, basically showing that you reasonably travelled on false papers. And so after Ademi, Parliament passed legislation to give effect to these provisions, to give effect to Article 31. So Article 31 had been forgotten about, and indeed, as the Criminal Court of Appeal irritably remarked from time to time, is still forgotten about by many duty solicitors, resulting in many people pleading and even being convicted of offences for which they shouldn't be. And years down the line, the Criminal Court of Appeal has to intervene sometimes. So defence is created against forgery, identity, deception and document falsification by Section 31, Section 31 of the 1999 Act. And it tightens up Ademi perhaps a little bit, requiring an asylum claim to be made as soon as reasonably practicable, and it looks at behaviour in a third country and poses the test of could you reasonably have expected to have been given Refugee Convention protection there. Okay. And the Criminal Court of Appeal has looked at these provisions, and they've said that a claim must be made as soon as reasonably practicable, which doesn't necessarily mean the earliest possible moment. And essentially, the Criminal Court of Appeal in Abdullahi and other cases have essentially upheld Adimi, no real shift from Adimi subsequently. Lord Wolfson, promoting the current legislation, says that the government felt that the Article 31 and Section 31 were being interpreted too broadly and giving too much protection by the Criminal Court of Appeal. And they say that they want to narrow it down. And that's what the wording of the new Section 31, sorry, the new Section 12 and Section 37 of the 22 Act aims to do. So what what this provision, which we're going to see in a moment, basically does is it sort of narrows down, perhaps we'll see, that might be contested, but it aims probably to narrow down the protection of Article 31 of the Refugee Convention, and it does so in order primarily to treat refugees in different ways. So refugees who behaved badly are going to get a much worse regime. No access perhaps to family reunion, or more difficult access to family reunion, and also no access to indefinite leave to remain settlement. The case law tells us, case law far more broad than refugee case law, it tells us that ambiguous words in English legislation need to be interpreted consistently with international treaty obligations. So if these provisions are vague, and I think they are a bit vague, then the natural approach of the judges is going to be to revert to Article 31 of the Refugee Convention itself. So there'll be undoubtedly litigation on that before too long. Whether it runs off criminal proceedings or whether it runs off JRs of settlement refusals or family reunion refusals, we'll have to see. But anyone could get these cases. I mean, your firm could get these kind of cases because, of course, family reunion and ILR is something that's hotly contested by private client asylum seekers. It's not just the provenance of legal aid in a way that, for example, the refugee definition has tended to be in the past. So here's the statutory wording, Section 12. Refugees are Group 1 refugee, they're the good guys, if they've complied with both the requirements of subsection 2 and also subsection 3. Otherwise, they're Group 2 refugees, they're the bad guys. Requirements in this subsection 2, are coming to the UK directly from a country or territory where their life or freedom is threatened, and presenting themselves without delay to the authorities. And then there's a pointer, there's another statutory provision we need to look at, which we'll get to duly. But first, Section 12, subsection 3. Where a refugee is entered or is present in the UK unlawfully, the additional requirement is that they can show good cause for their unlawful entry or presence. For the purpose of subsection 3, a person's entry into or presence in the UK is unlawful if they require leave to enter or remain and do not have it. Okay, so just going back again to 12.2, just to make sense of it. So the requirements are coming directly to the UK and presenting themselves without delay. You might say, to be honest, that these requirements are not massively different to Article 31 of the Refugee Convention. I mean, Parliament, I can't help but feel the government spokespeople were a bit overconfident about what they'd achieved in the statutory wording, but we will see, time will tell. And here's the other provision that goes with this, Section 37 tells us the refugee is not taken to have come to the UK directly from a country where they fled for asylum purposes, if they stopped in another country outside the UK, unless they can show that they could not have reasonably be expected to have sought protection under the Refugee Convention in that country. Notice one change here is that we've gone from Section 31 of the 99 Act, its definition was voiced in terms of a reasonable expectation of obtaining protection. But now this, on the other hand, looks at a reasonable expectation of having sought protection. So definitely that's a different focus. And also, what about, so that's looking at the third country scenario, and then 37.2 looks at the timing of your asylum claim scenario. So if you're a classic asylum seeker, someone whose asylum claim arose abroad, then the test is whether or not you claim asylum as soon as reasonably practical after arriving in the UK. But if you're a surplus refugee, so you claim, as the UNHCR handbook styles it, i.e. someone whose asylum claim arises because of post-departure events, then you get a bit of a leg up here. So if you were lawfully resident in the UK, student, visitor, whatever, at the time your asylum claim originates, then you only have to claim before your presence becomes unlawful. So it seems to me you actually wait until the end of your current visa. However, if you're unlawful at the time, then you have to claim as soon as reasonably practicable. So the upshot of all this, is that people do not want to dally in third countries in the event that we're advising them. Obviously, high net worth asylum seekers may get in touch early in their refugee journey, no doubt. So one thing that they should bear in mind is that stopovers are an issue, and another issue, of course, is that coming to the UK, people should, generally speaking, be claiming asylum sooner rather than later. Obviously, private clients are much more likely to have leave in another capacity when they come, but of course, some people want to do things in a certain order. Some communities, Bangladeshi asylum seekers, for example, however wealthy in my experience, want to go through every possible route before they claim asylum and end up with absurdly late asylum claims, which really wind up the Home Office and often antagonize judges, because this is a community which plainly is very politically involved, hangs out together because often witnesses will be coming from the community, often senior political figures, and it's really not obvious why it is that they didn't think it was a good idea to claim asylum sooner, except that is obviously someone in the system is advising them of that, and it probably isn't the best advice they've ever received. So anyway, but what all this does is certainly encourage one to claim asylum sooner rather than later, because not only will you get credibility issues with a late asylum claim, you will get Group 2 refugee status. Okay, blah, blah, blah. Okay, nothing really to add there. So the upshot of all this is that the purpose of classifying people in this way is to set up a discriminatory regime so that when we stare at the settlement protection appendix in the immigration rules, we discover that people don't get access to settlement unless they're Group 1 refugees. Interestingly, the Home Office have chosen to put humanitarian protection seekers into the same category. So humanitarian protection is kind of an innocent victim, of the downgrading of refugee status. Obviously, what's happened is that the Home Office have looked at all this and thought, oh, humanitarian protection was EU law, but it isn't anymore because we're no longer subject to EU law and we've revoked all this stuff. And so surely, therefore, we can do what we want to humanitarian protection, and we're going to give people a bad deal on family reunion and all the rest of it. And of course, that can matter, because if we've got clients who have a brilliant case in terms of being in danger abroad, but don't have a refugee convention reason, of course, they're going to be in the theatre of humanitarian protection. Appendix Settlement Protection tells us that refugees are expected to leave the UK as soon as they are able to, or as soon as they can be returned or removed. That is a general enjoinder, albeit made in the context of still permitting settlement for people who are Group 1 refugees. And I suspect here, and the guidance suggests this, that even Group 1 refugees may be getting a more active assessment of ongoing protection needs. That's what it looks like to me. A colleague of mine, sister colleague of mine, remarked that actually the Home Office policy has always been quite aggressive on active review, not always, but in recent years, but they haven't actually actively reviewed anyone. Of course, the current climate in which the Home Office can't actually decide anything suggests that they possibly won't be going looking for extra work beyond their core work, and with a backlog of what is 145,000 asylum claims, including 85,000 awaiting first decisions, auditing people who've already got refugee status may not be a priority. But anyway, the danger is there. The danger is definitely there. So these immigration rules, my goodness me, they're hard going, the immigration rules. Yeah, even though I thought I knew what they said, I still couldn't find the bits that said it. I do this for a living. So anyway, buried in the immigration rules, you'll work out. What you have to do basically is do a Control F in Part 11, the asylum bit, and find every reference to each concept. And then having done that, it may start making sense to you. But basically what the rules do, R339 QA1, is it defines refugee permission to stay, and that's what NICE refugees get, Group 1 refugees. They get 5 years, whereas Group 2 refugees get 30 months, subject to exceptional circumstances. Yeah, so you'll be able to put a case about why your client, if they do fall into Group 2 status, first battle is stopping them falling into that status. Second battle is to show that there are exceptional circumstances. Maybe they've got a humanitarian case to bring family here who are in danger. So the Home Office attitude to that is to say, look, that's not our problem. If people in danger can claim asylum abroad, they don't have to come here. So it's not like even that, which you might think is an obvious point to make to the Home Office, could be contested territory these days. Also, and this seems to be a general trend in the new rules, extension applications are to be made within the last 28 days of permission to stay, which that's previously been a guidance position, but it seems to be hardening in some of the new routes generally. Okay, just some observations on this here. So actually, because of the way the statute works, lawful entrants who fail to claim asylum in a third country could become Group 2 refugees, because both third country behaviour and timing of asylum claim behaviour can be targeted. And of course also students or anyone else who's declared an illegal entry because their asylum claim, for example, is deemed incompatible with the original premise of their immigration status, they could be declared an illegal entrant, at which point their presence will be unlawful, at which point they could be staring down the barrel of Group 2 status. That's another thing to think about. A interesting JR point, yeah, maybe more of a point for barristers to worry about than solicitors, but just to flag it up, yeah, because it's someone's going to be first mover in court on this. Section 37 does not say, in the opinion of the Secretary of State, unlike many statutory provisions relating to immigration or asylum. So there's going to be an issue about whether or not the JRs are direct assaults in which judges make up their own mind on these issues, what they call precedent fact decisions, or are they classic JRs in which the judges are just looking at whether or not the Home Office overlooked evidence or took leave of their senses, whatever. Okay, and when promoting the legislation, the Minister of State for the Home Office said some good things about how it was likely that people would not fall within the provision if they were if they were sexual violence or trafficking survivor or had serious health issues. Okay, right. I need to crack on a bit in terms of timing. So refugee convention, departing now that stuff, departing differentiation and moving to the general refugee convention regime. As I indicated, a lot of this is really a reshuffling of where things live. So if you were wondering where the definition of protection lives, or where the definition of convention reason or the definition of persecution, it all lives in Part 2, I think, of the 22 Act now. Much as always with the immigration legislation, much of this stuff operates, much of the 22 Act generally operates by amending the 2002 Immigration Act or other legislation, but not the Refugee Convention regime lives in the 22 Act. So this will become a firm friend of ours pretty quickly. Particularly serious crimes have been redefined to include crimes which in no way could rationally be described as particularly serious. Because now it's not a 24-month sentence, it's a 12-month sentence that gets you deemed to have committed a particularly serious crime. It's a rebuttable presumption, both in terms of whether or not you pose a danger to the community and whether or not your crime is particularly serious or not. But nevertheless, it now captures a much wider range of immigrant. And of course, UK is not like a lot of continental Europe. We give everyone massive sentences in the UK and then they don't serve them. But that does mean they get excluded from all this stuff. And in a sense, that's a bit half-baked, but nevertheless, that's what we want. Rishi Sunak expressly campaigned on the premise that this new provision was far too generous, remarkably, suggesting that his refugee scholarship is possibly not as good as his economics. But anyway, this is what we got now. Nearly everyone's going to get excluded. Credibility. Anyone who's misbehaved with the Home Office more broadly than before can have that held against their credibility. Any relevant behaviour the deciding authority thinks is not in good faith in dealing with the Home Office and in pursuing court cases. So watch out, especially JRs, because JR's high duty of candour. If someone gets nailed in a JR for not having put their full case candidly, that could now bedevil not only their JR and their legal costs, it could also bedevil their asylum claim. Standard of proof. This is the big one, standard proof. Obviously, as we all know, the nice thing about refugee status so far in the UK has been that for many years, right since the 80s, we've had the low standard of proof. So the question for Home Office decision makers and judges is essentially, is there a reasonable likelihood that you're telling the truth? That is an oversimplification of the pre-June position, but broadly speaking, I think we could summarize things as that. That's probably what first-tier tribunal judges, that's how they see it. And one important thing about the low standard of proof is that the benefit of the doubt should be conferred on asylum seekers in the status determination regime. However, now the provisions are changing. So the decision maker must first determine on the balance of probabilities whether the asylum seeker has a characteristic which could cause them to persecution for reasons of the Refugee Convention reasons, religion, race, politics, etc. Yep. So convention reason is to be established on balance of probabilities. Much more importantly, though, whether the asylum seeker does in fact fear such persecution in their country of nationality as a result of that characteristic. And it would seem that the intention of that piece of legislation is to change the standard of proof to balance of probabilities for assessing credibility. Big issue, big issue. I suspect quite a lot of judges who might accept someone's case, notwithstanding doubts on the low standard of proof, might not accept their case on balance of probabilities. And the Home Office too. The Home Office are also, going to be meaner, presumably, in assessing cases. And then once you've departed those two issues, convention reason and fear, everything else is on reasonable likelihood standards. So persecution, whether or not they're going to be persecuted, i.e. how bad is the harm they fear. State protection is going to be dealt with on reasonable likelihood standard. Internal relocation can be dealt with on reasonable likelihood standard, which is a funny one, internal relocation, because of course internal relocation can involve facts. So you could have your Indian asylum seeker could have a well-founded, could assert a well-founded fear of persecution in the Punjab, and the Home Office might argue that he can happily go and live in New Delhi. And then you might say, well, okay, relevant to his case is whether or not he has family in New Delhi. Oh, he does, say the Home Office. But on what standard of proof is that to be dealt with? It seems to me it's to be dealt with on the lower standard, even though it's a factual question, and we might have thought on the higher standard. So you see what this is going to make. This is going to destabilise tribunal decisions and Home Office decisions on an epic scale for years, because this will have to be determined by the Supreme Court what all this means. It's quite hard going. One massive issue that I can tell you about, right, is that humanitarian protection is staying with a low standard of proof. Because the Home Office tell us in their new guidance, one thing you need to be aware of is that enormous amount, as I discovered when I was doing HJT training updating over the summer, the Home Office have brought out about 100 new policies over the summer, including massive new policies on every aspect of asylum. And along the way, 70 pages of humanitarian protection policy. Along the way, it tells us that humanitarian protection is staying on the low standard of proof. So when we've been putting our cases, refugee cases, for the last, God knows how long, well, 15 years since HP was created, when you write your representations, you've been saying, no doubt, or going to court, you say, oh, the humanitarian protection case usually stands and falls with the refugee case, because if you achieve your refugee status, if you show that you face a well-founded fear of persecution for political reasons, against which there's no state protection, then obviously you would also have won your humanitarian protection claim, but who cares, because you want refugee status. Not in future, because the factual history of your case has to be reassessed on the low standard of proof. Massive issue that is going to revolutionize tribunal appeals and spin Home Office brains as they determine asylum claims at first instance. Okay. All right. Now, I think in terms of actually what I wanted to deal with, in terms of my narrow focus, I've now dealt with it. And although I've got more things I might say, I don't propose doing so unless we have spare time. So I'm now any questions? Actually, any questions arising from that? Yeah, and then if there are any questions, I can sort of try and work out if Raz has joined us in the meantime.
I'm here, Mark, so I'm happy to move on if that works for you. Otherwise, and of course, we've got time at the end of the session to deal with any questions that anyone has more broadly. I'm going to share the slideshow that I've got. I hope it shouldn't really. I mean, 2 years later, there shouldn't really be any issue with doing this smoothly, but there we are. Oh. Sorry, bear with me. Unless Anusha, you're on the line and you can share them for.
Yeah, I'm happy to share them for you.
Yeah, I'm sorry.
It's all right.
I think we recently upped our security on all the internal systems, so I haven't adjusted this. I'm sorry about that. Yeah, so can we go to, yeah. So can we make that full screen or? Okay, brilliant. Well, thanks so much, Anisha. I'm sorry about that. So I've tried to, because of time and because of the novelty of the act and because there's so much to get to grips with, I mean, normally I wouldn't put as much detail as I have in this set of slides, but I've also tried to make it as punchy as possible. And the starting point really about this, if we go to slide 1, is that there are several aspects of the 2022 Act that significantly changed the law on safe third country removals. And so in respect to the new removal powers, the most startling aspect of the 2022 Act's safe third country provisions is Schedule 4. And this schedule essentially gives the Secretary of State carte blanche to remove an asylum seeker to a third state without first deciding their claim. And so a person can be removed, as you've seen, I've tried to summarize what Schedule 4 says, if it's a place that a person's life and liberty isn't threatened for a refugee convention reason, or they won't be removed elsewhere other than in accordance with the Refugee Convention. In other words, the non-refoulement principle. And it's a place where a person can be removed without their Article 3 rights being breached, and it's a place from which a person won't be sent to another state in contravention of their convention rights. Convention here to mean Article 3 convention. and the person mustn't be a national or citizen of the state in question. And as you've already seen from Mark's presentation, Schedule 4 of the 2022 Act intersects with the existing certification powers in Schedule 3 to the 2004 Act. So far from simplifying and providing a single, a one-stop shop for people to go to understand where they stand in respect of their rights, unfortunately, one will have to look at this as part of the very large network of statutory provisions and the way in which they interlock with the 2004 Act, the 2002 Act, the 99 Act, and so on. And one will have to read all of those statutory provisions as a single code, albeit there's always constant political rhetoric about seeking to consolidate things, and the Law Commission is looking at that. But anyway, that's a side point. If we can go to the next slide. So the way that the Act is structured, the countries listed in parts 2 and 3 of Schedule 3 to the 2004 Act are presumed and apparently irrebuttably to be places where a person's life and liberty aren't threatened to the Refugee Convention and where a person won't be removed elsewhere. But it's also rebuttably presumed that there are countries to which a person can be removed without their Article 3 rights being breached, and from which a person won't be sent to another state in contravention with their convention rights. And the countries that are currently listed in Part 2 include all the EU and EEA countries and Switzerland, and there are no countries presently listed in Part 3. And the countries that are listed in Part 4 of Schedule 3 to the 2004 Act are presumed, but again, apparently irrebuttably, are places where a person's life and liberty aren't threatened for Refugee Convention reasons and where a person won't be removed for elsewhere other than in accordance with the Refugee Convention. So there's no presumption with respect to breaches of convention rights in those countries. And again, no countries are currently listed in Part 4. Now, go to the next slide. What Schedule 4 to the 22 Act also makes various amendments to Schedule 3 of the 2004 Act, and it does 4 things in particular. It abolishes the limited out-of-country appeal rights that previously existed for those certified under the schedule, and you'll remember all the litigation that previously went on about the viability of out-of-country appeals and so on. It doesn't provide for the UK to process a person's asylum seeker in a third country, and instead, it simply provides for their summary removal to that third country. And once they're removed, they'll be dealt with under the third country's laws, and the UK won't necessarily play any ongoing part. But the other striking feature is that Schedule 4, the other striking feature of Schedule 4 is that it doesn't require a person's asylum claim to first be declared inadmissible before they're removed to a third state. So in principle, it allows the Secretary of State to remove any asylum seeker to any third country that meets those conditions. So if we just move on to the next slide, I should say before that although Schedule 4 was widely described as offshore processing during the passage of the 22 Act when it was in bill stage through Parliament, that's a misnomer, and it's not a phrase that is used in the Act. This is the phrase of offshore processing. But the concluding point on the previous slide is that it follows that asylum seekers won't necessarily enjoy the full panoply of protections that they would enjoy in the UK. So going to the next slide. So at present, the Secretary of State's policy is to select asylum seekers for removal to Rwanda only if their asylum claims are inadmissible, and they've made a quote-unquote dangerous journey to the UK on or after the 1st of January 2022, and you've got the source there, which I've provided in the link. And it's to be noted that Schedule 4 was not yet in force when the implementation of the Rwanda plan commenced, and it came into force on the 28th of June this year. And so given that the stated purpose of the Rwanda plan is to deter irregular journeys to the UK from France, it may be likely that the Secretary of State will continue to select people for the Rwanda scheme on the basis of their having made such journeys. But the rejoinder is the one at the last bullet point. Schedule 4 doesn't require her to do so only on this basis, because as I said at the outset, Schedule 4 gives the Secretary of State carte blanche to remove any asylum seeker to any third state that will accept them with no statutory preconditions. So our understanding of how this operates through the prism of the Rwanda plan is not in fact the complete understanding. It's just the way in which she's most recently sought to exercise these new powers. So those are the new removal powers, and I'm going to move on then to inadmissibility, which is the next slide. And prior, as I said earlier, to the 28th of June 22, to 28th of June 2022, an asylum claim could be held inadmissible under paragraphs 345A to D of the rules, which you'll probably all be familiar with. And the criteria, and I'm going to deal with the history of this just simply to show how we have moved forward under the new act. But the criteria for holding a person's claim inadmissible were that they'd been recognized as a refugee in a safe third country, and they could still avail themselves of the protection of that country, and they'd otherwise enjoy sufficient protection in the third country, including the benefit of the principle of non-refoulement. And they could enjoy sufficient protection in that third country because they'd already made an application for protection. They could have made an application for protection in that country, but didn't. And there were no exceptional circumstances that prevented them from doing so. And they had a connection to that country such that it would be reasonable for them to go there to obtain protection. And these are all criteria that are familiar to those who litigated in the Dublin in the Dublin context for the last God knows how many years. So moving on to the next slide. And before I do so, for these purposes, a country was a safe third country for a particular asylum seeker if their life and liberty wouldn't be threatened by on account of the Refugee Convention, or the principle of non-refoulement wouldn't be respected. These are the counterpoints to the provisions in the rules that held that the claim was inadmissible. So you'd have to have shown that life and liberty wouldn't be threatened on account of the Refugee Convention, and the principle of non-refoulement would be respected, and the provision of removal on Article 3, inhuman and degrading treatment would be breached. But the Secretary of State was to admit an inadmissible asylum claim for consideration of the claim in the UK if either removal to a safe third country within a reasonable period of time was unlikely, or upon consideration of a claimant's particular circumstances, the Secretary of State determined that removal to a third country was inappropriate. But the new Act establishes a new inadmissibility regime, and you can find that in sections 80, big B to C of the 22 Act. And that's been inserted by section 16 of the 22 Act. Sorry, I should have said 80 B to C of the 2002 Act. And again, that came into force on the 28th of June and is materially different from the provisions as they were in the immigration rules. And in short, there are 5 conditions that an asylum claim is to be treated as inadmissible if they apply. And I've listed them here for ease. So they've either been recognized as a refugee in a safe third country and they can continue to access protection there, or they've been granted protection in the third safe country. And the result of that is that they wouldn't be sent from that state to another state other than in accordance with Article 3 or the Refugee Convention, and they can continue to access that protection. And the third condition is that they've made the claim, which hasn't yet been determined, or the fourth condition is that they were previously present in and eligible to make an asylum claim, and it would have been reasonable to have expected them to do so, but they failed to do so. So there's a question about penalties, which we'll come on to in a moment. And then the fifth condition, which is that in their circumstances, it would have been reasonable to have expected them to have made protection to a third claim to a safe third country instead of making it in the UK. So going on to the next slide, it can be seen that although these are broadly similar to the paragraphs in the rules at 345A to D, they're not identical. And in particular, whereas an asylum seeker who would have passed through a safe third state but had not claimed asylum there previously had to show that there were, quote, exceptional circumstances preventing them from claiming asylum, they now need only show that it was not reasonable to expect them to do so. And so what is a third safe country for the purposes of sections A, T, B, and C of the 2002 Act as amended? And it's defined as being a state where essentially their Article 3 and Refugee Convention rights won't be breached, and they won't be subject to refoulement. And if they are granted refugee status, they'll receive protection that's in accordance with the Refugee Convention. You'll remember maybe in the context of countries like Bulgaria and other places, people were being recognised as refugees, but they didn't have access to the panoply of rights that one is entitled to when one reads the Refugee Convention. So those have been put onto statutory footing within the 2002 Act. Moving then on to the next slide. If a person's asylum claim is inadmissible, it ordinarily won't be considered, and a decision to declare a claim inadmissible isn't a decision to refuse the claim for the purposes of Section 82 of the 2002 Act, and therefore there's no right of appeal. Now, the Secretary has a discretion to consider the claim. She determines that there's exceptional circumstances, and in the particular case, and that should be considered. Now, what we've seen so far in the Rwanda context is that the Secretary doesn't go on to decide that there are exceptional circumstances, but that's why, and we'll come on to in a moment, the preparation of cases in a very short period of time is extremely important. And before I go on to that, I said I would deal with the question of penalties. It's not clear yet whether inadmissibility and removal to a third state is a penalty on account of illegal entry or presence for the purposes of Article 31, which you heard Mark talk about in some detail and gave you the background in the cases of Adimi and Asfor and Mateta and so on. But that may make little difference in practice, because the reasonable to expect provision, quote, or the test in Section 80C as inserted is closely aligned with the Article 31 test as reinterpreted by Section 37 of the 2022 Act. It's also an issue that's come up in the Rwanda litigation. We'll wait and see what the court makes of it, but it's a novel area, and it's not clear, I think, either way. But coming back then to the practical points, which is what I'm going to end with. All practitioners representing asylum seekers who've travelled to the UK through one or more third countries need to be aware that their client's case may be considered for inadmissibility and removal to Rwanda. And removal to a third country through which the person has travelled is also a possibility, although less likely now that the UK isn't part of the Dublin III scheme. And the current procedure is that the Secretary of State serves an asylum seeker with a notice of intent soon after the screening interview, and then they're given 7 days if they're detained, or 14 days if they're not, to make representations. Now, that is a very, very short window, not least because often you might well be instructed well within that 14-day window, unless you are the kind of high net worth asylum seeker that we've talked about previously, who has made their plans in advance of arriving in the UK. But they are also less likely to have travelled through, say, third countries where they've been deemed to have stopped and so on. So it's a very, very narrow window, and it's critical, and it's perhaps obvious to say that they obtain legal representation during that period. And the first thing to do once you've got instructions is to urgently ask the Secretary of State to ask for more time to make representations, because and it would be unreasonable for the Secretary of State to refuse. And largely speaking, in the context of Rwanda, which is the only testing ground we've had so far, the Secretary of State has agreed to that, but hasn't provided generous periods of time in which to make those representations. Moving to the next slide, then the first priority is to work out why your client didn't claim asylum in a third country, so that you can make representations as to why it wasn't reasonable to expect, quotes, them to claim asylum there, or that there were exceptional circumstances. And I've given a list of common reasons there. They could have been, and perhaps the most compelling is that they were under the control of agents or traffickers, or that they were trafficked. there are also a host of other factual matters, including the subjective fears. So that they may have been destitute, they may have been abused, they may not know the language, they didn't know how to navigate the asylum asylum system, and so on. And you heard Mark earlier talk about the principle in the law that's been developed around Article 31 that asylum seekers have an element of choice as to where they claim asylum. But the clearest evidence probably is where you can get evidence or instructions that they were under the control of agents, and so there has been their agency has been dissipated by the enlarged role of the agent in controlling their journey and so on. So the first point is to get those instructions and make those representations, and then of course the second thing to do once you've got those instructions is to get expert evidence if it's available. Now, there are some good experts out there, not many, who have worked in the field of worked with the police and in the field of trafficking, worked with Interpol and others who are able to provide very good contextual evidence as to how these quote unquote networks operate, how these smugglers or traffickers or agents networks, whatever you wish to call them, operates, and therefore how the power relationship between essentially client, and this is one of the ways in which it is described as a commercial transaction, and agent operates, but also the level of fear that is exerted upon those who have no idea what they're doing and where to go. For example, they're told that if they leave the site of the agent, they will likely be punished, or that revenge may well be taken against their families in order to make sure that their reputations aren't compromised. And this is the commercial model that the Secretary of State often talks about when discussing what we would probably say is the false premise on which the scheme has been marketed. And so that takes, and self-evidently, some of these reasons that I've listed are more compelling than others. It's also not clear what's reasonable to expect or exceptional circumstances, how that will be interpreted in practice. So to a large extent, the field is open at the moment, and it's for us to frame our cases as coming within either of those two tests in the way that we believe them to be. And whilst the court is unaided by any authority on the point, that they will have to treat those words in the ordinary way, and it will essentially turn on the facts. But then if we go to the next slide, we deal with the issue of medico-legal evidence. So if we go to the next slide, sorry, the one after, well, we can deal with this. Yeah, I've just addressed this point here, but medico-legal evidence will be required in virtually every case. And those of you who have experience with asylum seekers will know that it's almost every asylum seeker will have suffered some form of PTSD and so on. But the reason that the medico-legal evidence is important is not simply for the reasons of making good an asylum claim, but in the context of inadmissibility, it's important in discovering and providing evidence of the state of mind of the asylum seeker and how their journey to the United Kingdom, the trauma that they had endured in the country of origin and during the journey to the UK, vitiated to a large degree their ability to make rational decisions, why they didn't claim asylum earlier, why they didn't go to the authorities and identify themselves and do whatever it is that they are said to be reasonably expected to be able to do. The extent to which they were able to understand what their situation was and the assessment of risk whilst they were in the safe third country. Because although these third countries are called safe, of course, these asylum seekers very often feel anything but safe. And those are covered earlier in relation to the control that an agent may exert upon you, but of course, just the residual fear and uncertainty about what's going on around them. So psychiatric evidence is extremely important to address those questions, and so one should be alive to that in this context. That's the new dimension when making these claims in the context of inadmissibility. And in every case, it will be essential to prepare a strong argument as to why Rwanda or any other proposed country of removal isn't a safe third country for that particular asylum seeker and why their human rights would be breached here. And so although one might be tempted to look at the wider position in the safe third country, quote unquote, actually, you're much more likely to win on your individual facts. And so far, we haven't got the judgment, for example, in the Rwanda litigation, but it seemed clear to us that was what engaged and interested the judges, and quite rightly so. And it's obviously much more challenging to show that a country itself has such systemic flaws that you're not going to succeed. Your asylum claim is essentially one that is not going to be properly ventilated or so on, than it is for you to be able to show that your client in particular suffers from conditions or was suffering from, was under the control of an agent or so on. And that was what vitiated their or compromised their position in that third country. Going to the next slide. Before I do that, I was just going to end on saying that some asylum seekers will find it very hard to rebut the inadmissibility decision because, for example, they actually claimed asylum in a safe third country, and in such a case, the claim is automatically regarded as inadmissible, and the reasonable to expect test isn't in play. So, as I say, it's in every case it will be essential to prepare a strong argument as to why that country isn't safe for that particular individual. So I'm just going to close there, and I hope that I've gone through the material quite quickly, but hopefully I've put it all in a fairly fulsome way in the slides. And there's a lot to digest insofar as what this Act has to say, and from what Mark has said and what Hannah is about to say. So hopefully this will provide a reference point for you to go back and refer to when you're digesting everything that's been said today. That's all I was intending to say for now, and I'll pass on to Hannah.
Thank you, Raza. Hopefully that has come up for everyone. I'm going to talk about accelerated detained appeals. And as Mark has touched upon, the relevant provisions can be found in section 27 of the 2022 Act. And it's worth noting that this provision has not yet come into force. There will undoubtedly be the need for regulations and tribunal procedure rules to be made before commencement. But it's worth having a think about what the provision says, because it will bring about quite considerable change in terms of appeals for detained individuals. I've set out section 27 here. And the provision will apply to people who are detained and who have made a relevant appeal to the first tier tribunal. So that will include protection and human rights appeals, appeals against deprivation of citizenship, and appeal rights in the respect of EU citizens' rights immigration decisions. And it will also affect people who are appealing against EEA decisions. So it may well be that your particular client group are affected by this new section. In terms of safeguards as to who will be subject to the accelerated appeal procedure, what section 72 subsection 2 says is that the Secretary of State may only certify a decision under this section if the Secretary of State considers that any relevant appeal brought in relation to the decision would likely be disposed of expeditiously. So the test, according to the statute, is merely how expeditiously, how quickly the appeal can be resolved. Now, when this provision was being considered by the Public Bill Committee, Tom Pursglove, who was Parliamentary Undersecretary for the Home Office, did say that through regulations and guidance, the Secretary of State would ensure that only suitable cases would be allocated to the accelerated route, and the cases would be assessed for whether they could be dealt with fairly under the accelerated route, and individuals would be screened for vulnerability. We don't have the regulations or the policy guidance yet to consider, so it remains to be seen whether those additional safeguards will be included. It is relevant that in relation to the previous fast-track detained system, the Court of Appeal in JB Jamaica did find that a quick decision means a quick decision that is fair and sustainable. So it may be that the interpretation by the courts of this definition, of this criterion of being able to be decided expeditiously, will be less harsh than apparent on its face. But again, that remains to be seen. The other safeguard provided for by Section 27 is that the tribunal procedure rules must secure that the first tier tribunal or the upper tribunal may, if it is satisfied that it is the only way to secure that justice is done in a particular case, order that a relevant appeal is to cease to be an accelerated detained appeal. It's unclear how exactly that will work, at what stage the tribunal will be considering that point, what the criteria will be for consideration. But that is something that wasn't present in the previous fast-track detained system. And it will be important, the detail will be important. So if an individual is allocated to the accelerated route, there will be very strict time limits, and any notice of appeal must be given to the first tier tribunal no later than 5 working days after the date on which the appellant was given notice of the decision. The first tier tribunal must make and give notice of its decision no later than 25 working days after the appeal was lodged. And any application to the upper tribunal must be made no later than 20 working days after the applicant gives notice of its application. So the time limits are much stricter than the present time limits for giving notice of appeal, which of course is 14 days. And of course, the 25 working days for the FTT to make its decision is extremely short, given that most appeals in the FTT on average take at least 3 months to come to the FTT, and a further 2 to 4 weeks for decision on average. So, I mean, this is clearly the Home Office's attempt to bring back the detained fast-track procedure. There are some differences. The detained fast-track procedure applied in some cases immediately after an applicant had their screening interview if they were an asylum applicant. The detained fast-track system was also defined in policy, whereas the new system, of course, has a statutory footing, and that will be relevant when there are future legal challenges, which there will be, because the statutory footing makes this provision more difficult to challenge. The time limits under the new system are slightly more generous than under the detained fast-track procedure. So, for example, under the detained fast-track, there were 2 days to give notice of appeal, whereas now under the new system, there are 5 days. But on the whole, it does appear that the fundamental problems with the detained fast track system, which were found to be unlawful by the Court of Appeal in 2015, do remain. And what the Court of Appeal said in Lord Chancellor and detention action was that the time limits are so tight as to make it impossible for there to be a fair hearing of appeals in a significant number of cases. And it does seem that this new provision, section 27, will carry with it all of the difficulties faced by the previous system. So difficulties in getting legal representation, in securing corroborative evidence in complex appeals, difficulties posed by vulnerable clients who might struggle to obtain the relevant evidence and who require additional time to give, for example, witness statements. And so it does seem that this new scheme is ripe for legal challenge, and how that will play out remains to be seen. In terms of practical pointers, what will be important is to front load evidence in initial applications. So whereas perhaps currently, especially under the legal aid system, expert reports, medical reports, trafficking reports might only be obtained at the appeal stage, it will be important to secure this evidence as early as possible before the initial decision, because if an individual is routed into the accelerated route and is unable to get out of it, there will be very little time and probably insufficient time to obtain that evidence. It's also important to obtain, in particular, medical expert evidence or trafficking expert evidence, if relevant, because that can be relied on when arguing that an individual is not suitable for the accelerated route. And as I say, we don't know what the guidance is going to say on who is suitable and who is unsuitable from the perspective of the Secretary of State. But evidence, for example, about the client's vulnerability in the opinion of a medical expert, or evidence that they may be a victim of trafficking as confirmed by a trafficking expert, will be highly useful in arguing that first, the Secretary of State should not certify the decision, and if they do, arguing and making representations to the tribunal that the client's appeal should be taken out of the accelerated route. That's everything that I thought I wanted to say about section 27. I thought perhaps now it might be useful, and with the remaining few minutes, to open up if anyone had any questions, not just about the accelerated route, but about anything that was spoken about this morning.
Hi, Hannah, and everyone who presented this morning. Thank you so much for that. That was really, really helpful. It's Nick here, Nick Rollison. Just to say thank you so much for that. Does anybody in the team have any questions at all they wanted to raise, just following Hannah's offer to answer any questions?
I mean, I should say that, and as I said at the end of my little bit, that there is a huge amount to digest, and it's taken quite a long time to get our heads around it, as everyone sort of alluded to. So I'm not too surprised if people would prefer to go away and have a look at the materials. And one of the intentions in putting forward such complete slides, as I say, normally I don't, personally speaking, like to essentially read out loud. But because there's so much that's new and so much of it's dense and interlocks with so many previous provisions, that it's probably, hopefully, will help aid understanding once you've gone away and had a look at it and been able to look at the corresponding statutory provisions and so on. But of course, anything that arising that does strike anyone today, please do feel free. There are no, I mean, this is all new territory for all of us, frankly.
Yeah, no, it's really, really interesting and also quite scary. So thank you so much for giving us the full run through of everything. It's really, really great.
If I could just ask a quick question, please. Yeah, first of all, thank you very much for that. It's really interesting for us. Really grateful for you taking the time to talk to us about it. What's the latest on the Rwanda litigation, and do we have a time frame for when we may hear back on that?
So we had the hearing in the middle of September. It was hugely expedited. I don't know how much of the background you know to it, but it was a hugely expedited hearing. I mean, far too expedited, really, to give anyone, frankly, a fair opportunity to get everything in order. But we did, and it was. I mean, for example, we asked for 2 months to get the material together, and we got a month, and we asked for about 4 weeks for a hearing. Asked for a 4-week hearing. We only got a week. And so everything was pushed through at pretty full tilt. And given the extent to which this scheme tries to row back on 30, 40 years of refugee law, I feel that the time that was allocated was commensurate with the issues at hand. That being said, Lewis, it was a divisional court sitting, and Lewis had read everything and in fairness to him, had digested everything pretty well. He was sitting with Swift. They're going to wait until they hear the asylum aid case, which is raising a point about procedural fairness and the accelerated procedure that you've just had Hannah talking about, albeit it's an accelerated procedure specifically to do with the way in which they've been processing the Rwanda scheme. And that will be heard towards the end of October, after which they will hand down judgment in this case. My sense is that they will probably hand it down pretty quickly after they've heard asylum aid. So we're looking at end of October, beginning of November. I don't know what, Mark, you think about that, what your predictions are.
Well, it'll be interesting, won't it? I mean, we'll see. I mean, my prediction would be that we probably lose on most of the generic issues, the high-sounding principles, and but from the reaction of the court, they were very unimpressed with the processes adopted by the Home Office in our individual cases. So I think it's quite likely that the cases will win on their facts, which may put the Home Office back a bit. But I'm not sure that the scheme will be declared unlawful. But we'll see. We'll see. There was surprisingly strong evidence about problems in Rwanda, because actually Rwanda's record on human rights is nothing like as bad as one might have imagined, given some of the criticisms. But once it was dug into sufficiently, there are real issues basically about freedom of speech in Rwanda. And given that the Home Office main argument is that Rwanda can be trusted to look after the refugee because of a memorandum of understanding, this is a regime where no one would ever dare put their head above the parapet to criticise the memorandum of understanding. So there is, you never know. The court's going to have to grapple with that. So we'll see. We'll see.
Yeah. I mean, one of the issues was that there was a huge amount of important evidence that should have gone in on the individual cases and on the broader cases from UNHCR, but wasn't admitted because of the very tight way in which the court regulated the directions. And so there's certainly more to come. And I agree that the individual cases are likely to win, or more likely to win, and the wider points of principle are likely to struggle. There's an interesting question as to what will happen if the individual cases do win, as to how you proceed with the appeal. But again, it kind of fortifies the point I was making earlier, that getting the evidence right in your individual case is absolutely critical. I mean, even in the cases that we had, and the clients were very well represented, put it that way, in terms of the number of lawyers on each case. And even then, it was a real struggle to get the medical evidence in on time, and we struggled procedurally with getting that evidence into the proceedings. And so it may be that we'll have to make further representations if we don't win in front of the divisional court. So yeah, again, it is an object lesson in what we've learned already, that getting it right from the first instance is really important, and it is a challenge, but it's doable. But it is a challenge. You know, there's no hiding from that. Okay, well, I mean, I don't know if anyone has any other questions, but and I'm just looking as carefully as I can to the two screens of attendees. But if there aren't any questions, as I say, we're very happy to follow up with anything arising from this material, as I say, which will take some kind of cogitation and digestion. And please do feel free. And it'd be very interesting, frankly, to have the conversations and to work this through collaboratively as much as anything else. So, and I think you've probably got all our details somewhere in the material, but do feel free to get in touch and to ask any questions. There are, frankly, no silly questions as far as this new scheme is concerned, given that the promoter of the scheme doesn't know what they're doing themselves. So unless anyone has any questions, we can leave it there, I suspect, and just give our express our thanks for joining us. I'm sorry that it's been much postponed over many months, not least because of the Wines litigation, amongst other things. But hopefully, as I say, it's given us all some time to reflect on things. And thank you for coming and spending the lion's share of your morning.
Thank you so much. It's really
Thank
good.
you again.
Thank you.
Thank you.
Thank you.
Thank you.
Take care.
Thank
Bye-bye.
you.
Thank you. Bye.
Thanks very much. Thanks so much.
Thank you. Bye-bye.